If you commit a crime, chances are that you may have trouble crossing into foreign borders. That's certainly the case for Canada and the US. Let's talk about the differences in inadmissibility with respect to Canada and inadmissibility with respect to the United States.
Very much different from each other, even though you'd think that they were quite similar. Canada's rules are very strict with respect to criminal inadmissibility. The most famous one, of course, is if one is convicted outside of Canada of a DUI, driving while impaired, driving under the influence. What happens?
The first thing is it depends upon how long ago you were convicted, but if it was a recent conviction, then you definitely need to apply for special permission to enter Canada by requesting a document that's called a temporary resident permit. To me, this is a very serious crime. And it's crazy that if you are a Canadian person and you have a DUI on your record, no problem, you can enter the United States. So why is that?
Okay, why is that? Canada basically lists its grounds of inadmissibility as to how serious the offense is. Basically, almost any offense might render you inadmissible to Canada, not municipal offenses, not provincial driving offenses, but anything that's in the criminal code will probably render you inadmissible to Canada.
Basically everything with the exception of trespassing. It's a pretty low threshold.
The United States, on the other hand, the criminality that renders you inadmissible to the U.S. is whether or not the crime is a crime of moral turpitude.
So is there a list?
There is a list. It's not an exhaustive list, but some of the very strangest things are not crimes of moral turpitude. Driving while impaired. Several convictions for driving while impaired in Canada. You are not inadmissible to the United States, and away you go. One of my most bizarre situations is that what is not a crime of moral turpitude? Spousal assault. Domestic assault in the United States, for the U.S. purposes, is not a crime of moral turpitude. There's a great differential between what Canada thinks is a crime, which is basically what's listed in the criminal code, and what the U.S. thinks is a crime, which has to be interpreted to be a crime of moral turpitude. Having said that, most of the traditional crimes, theft, fraud, larceny, any of the violent crimes are crimes of moral turpitude. A surprisingly big group of crimes are not. That's the big test. When evaluating whether one is inadmissible to the United States or Canada, it takes evaluating.
Canada, there are some regulations regarding passage of time. For example, if 5 years have passed since the completion of your sentence or 10 years have passed since the completion of your sentence, there's different types of applications in both of those circumstances. 5-year situation, you can apply for what's called rehabilitation, and that takes away your inadmissibility forever, provided that you don't commit any further offenses. Even further beyond that, if you've only been convicted of one crime, after 10 years, you can make an argument that you're what's called deemed rehabilitation. For the U.S., in order to overcome inadmissibility, you have to apply for what's called a waiver. Is there a permanent waiver?
There is no such thing as a permanent waiver in the United States. If you've been convicted of a crime that renders you inadmissible to the United States, you are permanently inadmissible to the United States. You can obtain 5-year waivers, 5 years, 5 years, 5 years. That allows you to go to the United States, but you cannot eradicate it permanently. Not quite true if you apply for permanent resident status. And in the process of applying for permanent resident status, you may also apply, it's very complicated, for a permanent waiver. That could wipe it off the record, but that's a very lengthy and onerous process.
I think the main takeaway from this discussion is if you have criminality and you're traveling to Canada or the US, always confer with an immigration lawyer. And a hot tip for employers is if you're sending your employees to carry out activities on your behalf in another country, such as Canada or the US, you need to make sure that they don't have criminality in their past, because that has a potential of impacting the work that you have in a foreign country.
Favorite question that we're asked: if I've been convicted in Canada or charged with an offense in Canada, will the United States know about it? And the answer is Canada and the U.S. share information on a lightning bolt method. The United States may even know before the rest of Canada knows if you've been charged with an offense. You can't risk it. We're asked, well, what if they don't know at the border? Can I still go? Well, it's sort of like saying if I rob a bank and get away with it, it's okay. It's not.